Welcome back. Who, how and why? Put brutally, those are the three questions a coroner has to answer when investigating a death. Seemingly simple questions, but sometimes so hard to answer. Sometimes impossible. A coroner can only investigate certain types of death: unexpected, accidental, violent, under anaesthetic, or a person in care. They can do that in their office, or they can do it in a court in an inquest, which can sometimes be routine, yet often can provide some of the most emotional, tense, and bizarre courtroom moments you will ever witness. In the coming weeks and months in Western Australia, headlines will be writ large about inquests set to be held. Cleveland Dodd, the young man who died by his own hand in the custody of WA's Department of Justice. JC, the young indigenous mother shot by a police officer in Geraldton. And Lisa Govan, the young woman last seen outside a Kalgoorlie bikie den in 1999, and then never seen again. All inquiries which all the families involved hope will provide some answers, some truth out of death. Joining us on Court in the Act today to try and pull back the curtain a little bit on the coronial process is Noor Blumer, Director of Blumer's Lawyers, whose practitioners are superbly well practised in representing those hoping for answers out of an inquest. Such a pleasure to have you on, Noor, and in the studio. Thanks for coming.
Oh, love to be caught in the act. Thanks, Tim.
So, as I mentioned, your firm specialises in medical negligence and personal injury, which sometimes, tragically, can end up with a coronial inquiry and potentially an inquest. And the bare bones of those processes are pretty simple: identity of the deceased, how the death happened, and the cause of death. But wrapped up in that can be a myriad layers of sort of investigation and litigation and mystery and intrigue sometimes.
Litigation is very complex, and if you have the coronial process first, it really lifts the lid on a lot of the questions and the information and the facts that we would otherwise be looking for. And it also gives the family representation at the inquest, which although the counsel assisting will assist and will ask some questions, it's not quite the same as having your own team and having your own questions asked, because they're often very different to what people would expect and may not otherwise be asked if you're not there with your own people.
And we hear a lot about feeling like you haven't got a voice in a process, whether it be a criminal process or in this case a coronial process. And the fact that a family of the deceased or an interested party can have their own lawyer and be instructed to ask their own questions regardless of what anyone else asks. If you want to know it, you have the power to put your lawyer in the place and then get them to ask that question, that word, those words, if they actually want to.
Exactly. And they really enjoy that. It makes them feel better and that they've been heard.
And the coroner's role, it's clearly laid out. It's got its own Act of Parliament, the Coroner's Act. And so that's their rule book. And that presumably means that a lawyer involved in a coronial case, or do you have pretty tight guidelines about what they can look for, or is it a little bit looser than a criminal trial, for instance?
Technically, the rules of evidence are a little bit looser, but in reality, most of the people there, they're used to that kind of system, so it is, while a little less formal and a little more open, it's very similar. So people get to be called to give evidence, they have to be cross-examined, or they can be cross-examined, and it's all on the record, and they have to tell the truth, and all of those things have to happen.
And it's in your experience as a lawyer and a manager of lawyers who deal with inquests, is there a particular skill set that you find that is needed there? A different skill set, perhaps, to a criminal lawyer or a civil lawyer?
Not a different skill set. However, you've got to be mindful of the fact that it is inquisitorial, and you are not. The coroner is not allowed to make findings as to liability that would be useful in a civil matter. So you've got to be careful not to forget yourself and cross that line.
Yeah.
Just stick to the facts and what actually happened. But often the overlap is huge.
Yeah. And having covered, well, I dread to think how many inquests over the years, the one thing that strikes me about it is that a coroner is a much more hands-on judicial role than a judge in a trial, say. The judge will instruct the jury on the law and obviously have legal argument with the lawyers. The coroner can get involved. The coroner can ask their own questions if they don't think the right questions have been asked.
Well, they certainly can, and in fact judges can do that too, but most choose not to. But we have seen instances where judges will ask, and I've often seen judges say, I just want to know this, can you answer that one? So, but yes, the coroner has more of a hands-on, and they've got, as I said before, counsel assisting. So they've actually got their kind of own voice as well in there to rally the troops and to ask those questions so that they don't have to ask all of them.
And ultimately, it's all about trying to get to the truth.
The truth.
Yeah.
The truth.
So, earlier this year, on Court and the Act, we did cover the case of Cleveland Dodd, the first young person in WA history to die in custody. He was just 16, being held in the notorious Unit 18 at Casuarina Prison, a maximum security adult facility which had a piece carved out of it by the state government to house what they said were the most troubled and troublesome cohort of young detainees in the state. Even as that carve-out was happening, advocates were warning that the solution was unacceptable and it was dangerous, a tragedy waiting to happen. And that tragedy did happen in the early hours of October the 12th, 2023, when Cleveland was found unresponsive in his cell by a guard. Ordinarily, a coronial investigation and inquest can take years to eventuate. The backlog in WA's coroner's courts are always significant. But certain cases demand certain actions, and the inquest of Master Dodd was expedited and started this April with 3 questions: who, how, and why. The first 2, pretty simple to answer. There was no doubt it was Cleveland in that cell. There was no doubt that he had hung himself in there. But why? That is the question which in this case begs a million more questions. Like, why was he there? Why didn't he come out? Why was the system under so much pressure that a teenager ended up dead in a maximum security jail cell? And why, when he asked to see a particular nurse and threatened self-harm numerous times on the evening, was he not somewhere else, somewhere better? Nor, while inquests are always about the death of one person, or almost always about the death of one person, they can often morph into an inquiry, into a whole system. How much power does a coroner have in compelling powerful agencies to cooperate in their inquiry?
Basically the same as a court. They you can be subpoenaed or summoned to attend. You must answer questions unless you've got a very good reason not to. So you can only interview people. You don't interview agencies because they're just made up of people, basically.
Yeah.
So you can, very strong powers, and if you don't follow their direction, then you can end up with serious criminal consequences and fines.
And those powers go for individuals that might, for instance, be a person of interest if there was a possibility of criminal action, or they can go to chief executives of hospitals and directors general of powerful government agencies, and like anyone. Ministers could be called, for instance, if the coroner thought it was going to get to the truth. Yeah,
the only one that can't be called is the coroner.
Yeah.
So I think it's gloves off for just about everything else.
And your firm, in a similar case, represented the family of Aishwarya Aswath, who was the little girl who died 2 hours after being brought into WA's multi-billion-dollar children's hospital. And the inquest into her death just about turned into an inquiry into an entire health system. So you're representing people, individuals that have gone through a horrible ordeal. But so, what are the challenges in taking on a case like that when you're up against the system and you're representing one person or one family in this
One
case.
family. And it's very hard because you want to get out what they want as well as respond to everything that's happening. And in a way, we ended up taking pretty much of a quite a big lead in that case.
Yeah.
I believe that our team of Tim Hammond, SC, and Ian Murray and Nikki Spade actually did an incredible job. They have a lot of expertise both in, analysing the medical situations and being able to ask the right questions. And they're often very technical medical questions.
I mean, where do you start there? I mean, because you've got the Department of Health, you've got the government obviously under pressure. You've got, it must be like looking up at a pyramid and thinking, how am I going to climb it?
Well, you start with a brief, so they give you a whole lot of documents. But what happened in this case was, and of course there was several people represented, several of the doctors, the government,
nurses,
the nurses union. They're all there, and what would happen is they'd be getting ready for court the next day or whatever, and then right at the last moment, a whole heap of documents would come in that they'd never seen before, that they would have to deal with. I mean, how are you supposed to deal with reading it, understanding it while you're on your feet? I mean, I think there were some very many late nights spent just dealing with that. Now, of course, it was wrong for those documents to be so late, and you often wonder about that. Is it that they've just found them? Why are they so late? Has somebody been sitting on them? Did somebody fail to make a decision? But it makes it very tough for the team. Plus, you're running the gauntlet of the press every day outside the court, and it's you're under a lot of scrutiny. I think it's very good legal work, though.
I mean, it must be, hugely challenging because in the Ashwaria case, for instance, on the ones your clients are a family deep in grief, so you've obviously got to be sensitive to their to their needs, and I witnessed myself Ashwaria's mum carrying a picture of Ashwaria physically into court every day and placing her by her side. At one point the coroner frowned at that, but I think then I think one of your lawyers actually made the point, well, that is why we're here, Your Honour, and eventually that picture is allowed to stay. So you're dealing with the human emotion of it, the legalities of it, and then the technicalities of it, ultimately to try and get exposure, because I suppose that's what the family wanted in this case, and it certainly is in the Dodd case.
They don't always want exposure, but this case they really did. They really care. The family really cares about systems and improving so that it doesn't happen to someone else. But I've had clients bring ashes in, put them on the table, and all sorts of things like that do happen. Photographs are quite common. It really helps to deal with the grief if people get a say and feel like that person that they've lost is there. And I remember one coroner we were involved in, and it was, in the end, the sister of the deceased sort of just blurted out when somebody was giving evidence and said, no, that's not right. But she got to have her say, and she felt a lot better about it. And in the end, they changed the law in that particular case. As they've changed some things in this case, Ashwaria's case, and the government certainly says that they have changed some things, and hopefully there might be some others down the track as well.
And I've certainly seen that as well, because it's every coroner I know always says at the start of an inquest, you are going to hear things that are upsetting. You are going to hear things that are, that are going to live with you for a long time. And coroners do give those families a little bit of leeway, a little bit of space, probably more than you get in a criminal court, I would think, just to express themselves.
They certainly do. Yeah. And the other thing that happened in that case is a prime example. Some of the medical staff that were involved and there during the death really gave some very compelling evidence, and I think it affects them terribly as well. And we need to be, when asking them questions, we need to be sympathetic to the fact that nobody wanted anybody to die. It happened, and there were reasons and there were shortcomings. But you have to accept that doctors and nurses, they want people to live and get better. And it's very hard for them emotionally as well, and they need their supports as well.
And you've spoken publicly before, obviously, and just mentioned it then about media and publicity. It's an open court, and
Yes.
inquests often surround very dramatic or newsworthy deaths, if I can put it that way. That must be a balancing act as well between sometimes courting the coverage if your clients want it, but also protecting them from that coverage as well.
Every client is different. They're a client that came to us who already had a huge media presence, so that was something we had to deal with. I've got other clients that I are convinced to say nothing, and I try and deal with that. We actually have media advisors who will handle things and will take the inquiries and will respond on our behalf or on behalf of our clients. So every case is different. But it's more now that people do want the publicity, because I've noticed that there's more pride and less shame. So it used to be that, for instance, if you were sexually assaulted, you never wanted anybody to know about it ever. But we've had some real leaders who have come out and been open, and actually that has brought change. And I can't criticise it, although sometimes for my own clients' best health interests, I say to them, enough, you can't take this anymore. Stop answering the phone, change your number, change your address, go on a holiday, do something different. But do not think that every time somebody rings, you have to answer them.
Yeah. There have already been days of devastating evidence in the Cleveland Dodd inquest, and there will be more to come, with the hearing before coroner Phil Urquhart due to resume in July. In the same month, another inquest will be held in 2 parts, and it will begin. Yamachi woman JC was 29 and very fragile on September 17th, 2019. She tried to take her own life less than a week before. And after being taken to Perth in a rush for treatment, she was then given $50 and told to get back on the bus to Geraldton on her own. When she got there, she found herself in conflict again with her own mental health and her housemates and family, which is how she came to be on a street, holding a knife and a pair of scissors, and why her worried family had called police for help. That police presence eventually amounted to 4 police cars and 8 police officers. 5 of them stayed in their vehicles, 3 got out, and within 16 seconds, one of those, former First Class Constable Brent Wyndham, had fired a shot. That bullet hit JC in the stomach, severing a vital artery. She died in hospital the next day. And following external outrage from family and community and an internal inquiry by the police, the officer became the first in almost 100 years to be charged with murder in Western Australia. That trial was one of 2 stories, either an officer displaying a reckless disregard in opening fire, or an officer in fear for his safety in the face of a blade and doing what he had to do. The jury sided with the officer and acquitted him of murder. But now, nearly 3 years on, a coroner will get to ask their own questions. Again, who and how are not in dispute. The why in this case will focus on why was lethal force used so quickly, with an emphasis on the way WA police and First Nations people interact. Nor, like many other aspects of the justice system, cultural issues, sensitivities, and their place in our 2024 society play a big part again in the coronial process and the purpose of holding inquests and coronial inquiries.
They certainly do, and I believe that most courts and jurisdictions like the coroner's court do undergo training on cultural sensitivity and those matters. And we saw it particularly in the coronial inquest into the death of Kumanjaya Walker in the Northern Territory. And in that one, they've actually been online. You can actually listen to it in the Walpiri language. And also, that has uncovered racist behaviour. So you can see how far the coroner can go.
Yep.
That couldn't, and evidence that couldn't be brought in Zachary Rolfe's criminal trial could be brought before the coroner.
Yeah.
So it's really opened up a whole, and in fact, I think Zachary Rolfe tried to keep a lot of those things out, but actually the coronial jurisdiction is pretty broad.
Yeah, and that's I think the key question in this one, because there's evidence that is admissible before a jury which goes to the criminal behaviour, but the inquest can broaden it out and bring in things that a jury might never have seen and a judge would have sort of never contemplated them seeing.
That's right. And I mean, it's a bit like the difference between the criminal standard and the civil standard. It's a lot easier to prove something on the civil standard, and even more so in an inquiry like an inquest. It's very broadly open. But don't forget that evidence can't be used in other proceedings.
Yeah. Do you think our coroners' courts are getting better in this in the understanding of the differences maybe between cultures and what a person in that culture passing away can mean?
I think they are getting better. And I was speaking to someone recently who spent a lot of time in the Northern Territory system, and she was saying that the lengths they go to, in fact, she's now in the ACT. She's the DPP there, and she'd done a lot of prosecutions in the Northern Territory. And she spoke very compellingly about how even to have somebody explain why a person would say yes all the time when that's not what they actually meant, for instance.
Yep.
And or also the role of some interpreters were too judgmental because they were actually putting their own cultural interpretation on what the response should be rather. So there's all sorts of idiosyncrasies in any culture.
Yeah.
In every single culture has its own special ways of dealing with things. You know, like the ones that when they're saying yes to something, they're shaking their head from side to side, or vice versa.
It's funny you should mention that, because today my colleague Phil Hickey has revealed that the dates for the inquest into the death of Josh Warnicky, the young man who was found dead at the side of the road in Broome a few years ago. A chap called Gene Gibson was convicted but then acquitted of that because of basically two things: cultural insensitivities amongst the police and them failing to use an interpreter when they were interviewing him.
Yes.
And he's a Walpiri man too. So those, I'm sure all those issues will be flushed out in the inquest into Josh's death as well, because finding out what happened to him is the key, but the fact that Gene Gibson was arrested, charged, convicted and then acquitted because of those cultural snafus, shall we call them, they're probably a bit more than that. It will be interesting to see how a coroner eventually deals with that in terms of where he goes, what measures are taken really for those people on country to be able to know what's going on in the courtroom, presumably in Broome or Perth. And so in this case, the JC inquest, how usual is it to have an inquest after a criminal procedure has gone through the courts and run its course? Well,
the law is that in the Coroner's Act that the coronial can't continue or if there's criminal charges to be dealt with. So it will have to, and sometimes you might start with the coronial and then there's criminal charges and then you have to suspend it and then you can come back to it, or sometimes it just doesn't start at all until the criminal charges have been dealt with, as we saw once again in that Northern Territory case.
Yeah. And as you mentioned, a coroner sort of can't prescribe blame. They can't, particularly after a not guilty verdict, because as a coroner says in sort of every published inquest finding, their role is to find the facts, not point the finger, basically. Yes,
but they can refer things to the... So let's say there's been no criminal charges and the coroner finds that perhaps there could be, then they can refer the matter to the DPP or the police and provide... they've got to do that in good faith and that's one of the things, one of their powers.
Yeah, which is a significant power. I mean,
It is.
Handing over a batch of potentially damning findings or evidence or, transcripts or whatever it might be to the police and saying, I want you to, as a coroner, I recommend that you look at this with the clear indication that there might be something there that could lead to a prosecution.
And it doesn't mean that they'll actually prosecute somebody or charge them, I should say, but at the same time, it shines a light on it, and I think in those situations it would be properly looked at. And if there was, but I've seen many times there are times when they don't proceed to a prosecution.
Yeah. And as you say, the coroner is the ultimate arbiter in that court. And from what they write or what they find, individuals can, come out looking pretty bad.
Yes.
Sort of defamation or anything like that's not an issue with the coroner, is it? As you say, they can't be. They certainly can't be called to be in an inquest.
No, well, all court proceedings are immune from defamation proceedings, more or less. There's possibly an exception, I don't know what it is, and coronials are included in that. And the coroner can't be sued for defamation or for any legal proceedings arising out of it, provided he's acted or she has acted in good faith. So you're pretty safe, but of course there's a rule at law that you can't use documents or information you've obtained in one, or documents in particular, or evidence in one proceedings, in another proceedings, without going through a certain process. But in particular, they can require people to give evidence, or a coroner can, that would incriminate them on a criminal standard and make them do it. They give them a certificate to say that can't be used against them, the actual evidence itself. However, it's out there then, and then the police could go back and get the primary source or get an interview or interview witnesses or whatever it is they need to do, get what forensic... It's a pointer, as you say, but they can't actually use the evidence itself. So it's a little bit of a protection because you can imagine a lot of people would just, as they say in the States, plead the fifth.
Yeah, plead the fifth.
So we don't have a fifth or fourth, but we do have, you don't have to incriminate yourself. So, yeah.
And the coroner also has the power to make recommendations.
Yes.
So at the end of an inquest, they can recommend to whatever government department or entity that they want to say, I think you should consider doing this. How much weight do those recommendations hold in your experience, Noor?
Well, I've seen laws change, and I've seen in Aishwarya's death, there were 5 recommendations made, mostly about staffing and policies and procedures that should change, and usually a sensible government will work on those changes and plot responses to them. I know in that particular case, the government immediately said, well, we've already done this X, Y, Z, and I'd expect people like you, Tim, to hold them to account if they don't. And the members of the public and the family and so forth. So they really, most of these families that go public really do care about it not happening to someone else. So these things are very important. Like the phone, they now have in emergency departments where you can ring if you're not certain. So there's all sorts of things that happen.
Time is also something that does not restrict a coroner. They can call an inquest into a death at any time, regardless of how long ago that death might have occurred. For example, when the inquest into the death of Lisa Govan begins on November the 4th this year, it will be 25 years and 1 month since she vanished. The last sighting alive of the 28-year-old was outside the Kalgoorlie clubhouse of the Club Derro's bikie gang, and rumours have swirled across the 2 decades since about what or who happened to her after that. There have never been any criminal charges laid, but investigations have continued and may well culminate in astonishing revelations in public, in court, in November. The West's chief reporter and chief friend of this podcast, Ben Harvey, revealed just last week that secret surveillance recordings of police officers consorting with those bikies suspected of killing Miss Govan could be played at that hearing. Questions about why it took detectives more than a week to raid the clubhouse, despite knowing that Miss Govan was there the night she vanished, could be asked. And whichever coroner is rostered on that week will likely be tested themselves as to whether they will be able to break the bikie code of silence, which has also suffocated that investigation. Noor, you just touched on it then. A coroner, they have wide-ranging and pretty heavy-handed powers at their disposal in terms of compelling witnesses to come to court and then answer questions that are put to them.
Yes, they do. There's a $100,000 fine or 5 years imprisonment maximum if you do not obey a summons, order or direction of a coroner. Now, there's some lesser offences as well that they can use, but that one's really fabulous, isn't it? I think that's quite good.
Yeah.
I mean,
disobeying the coroner. I mean, that's literally in the law. If you disobey the coroner, I mean, that is, you know, you must.
You just
must.
Hope you're not married to one. That's
well,
but I remember. But I've seen people when I used to do criminal law in jail because they can't tell the truth and they're taking the rap for someone, and they would rather do that than be killed. And that's the situation in some should we say criminal groups where the fear of death overcomes all the rest of it, and they don't care about, well, they do care about going to jail, but they'd rather be alive.
They care more about the blood pumping through them, and that happens all the time. I mean, there are in high-profile cases, suppression orders are made specifically to protect the identities of people that might become key witnesses in a trial. And there's a massive trial coming up in October involving a bikie that might have allegedly ordered the hit on another bikie, and the person who pulled the trigger, we are still not allowed to say his name, even though his identity is widely known in underworld circles. But the court still thinks that his identity is worth protecting. So,
well, I think if he is in prison, it's not one of the safest places to be if you're wanting to hang on to your life, because there can be people in there. They're very well connected. All sorts of things can happen, and people do get killed in jail if they're giving evidence or doing things like that. And yeah, anyway, very sad.
And in this context, that would sharpen up your thinking as well, because I'm talking about a rock and a hard place. You've got the coroner saying, you have to tell me what you know, otherwise you could go to prison. If you do say what you know, you could end up somewhere even worse. And then, as you mentioned, the coroner can then if that reticence emerges on the witness stand, a chap or someone turns up and says, I literally can't tell you because it's going to put me in trouble either with the law or someone else, then the coroner can issue what they call a certificate that gives this witness at least protection against prosecution and self-incrimination.
It doesn't protect them from prosecution. It just says that evidence can't be used. So it doesn't actually mean they can't be prosecuted and they can't be tried. They just can't sort of lift that evidence that's been given or provided to the coroner and use that.
So they couldn't, for instance, take the transcript and transpose it into a criminal and said, this is what you said on the 28th of January 2024 in the coroner's court. The police would then have to go back, reinvestigate, re-interview presumably, and then go from there, use that as the starting point.
And we suffer the same fate in civil proceedings. So we've got a case at the moment where the defendant is in jail and being convicted of pedophile activity, and our client who is suing him, we can't we can't directly lift the evidence and use it. I mean, there's cases that say you can, but there's also the Evidence Act says you can't, and it's a very complex area of the law. And so to be really, I mean, we're not going to lose that case because he's been criminally convicted and he's been through all the appeal and he tried to go to the High Court and failed. I'm very confident that we're going to win this case, but at the same time, on a civil standard, because the civil standard is so much lower, but at the same time, we're having trouble working out how to do this, and he's self-represented, so it's fun so far.
and it's. We started off the podcast. It's about the truth, right? The inquest is ultimately about the truth, and that is what the coroner will ultimately try and come to some conclusion about what happened, if it's possible, on the evidence presented. But as I mentioned, in between that are all the millefeuille of the layers that lawyers have to deal with, families have to deal with, the coroners have to deal with, the counsel assisting have to deal with, which makes the coronial space unique in the judicial hierarchy, really.
Yes.
Do the lawyers you work with and instruct enjoy the coronial inquiry process, or enjoy is probably a wrong word.
I can't stop them, really. I mean, Ian Murray, really, he ran his own without counsel recently very successfully. When you get into it, it is a certain type of, particularly, I mean, we're usually doing medical ones, but we have others coming up that might be more about, deaths in custody or people that have died in some other way. So we do get other death cases as well. But it is, and it's a standing on your feet job. So most solicitors don't always stand on their feet. There are solicitors who are also barristers and do a bit of both. And as solicitors, we're allowed to do as much advocacy as we like. But it usually takes a team. So you don't want to be standing up there on your own and not having someone else there feeding you the documents, helping you out, taking the notes. So it's always a two-person job. And and it's something that you either enjoy or you don't. But the lawyers in my firm that have done them really enjoy them, and I've enjoyed them as well.
And ultimately, from our conversation this morning, it sounds like that giving a voice, providing a voice, providing the advocacy that one person or one family couldn't possibly get themselves, given the situation that they put in, is the driving force behind, well, particularly your firm, but other lawyers that specialise or practice in this area. And
a lot of them can't afford representation, and that's why they do use counsel assisting, which is not a bad option at all. But most people can't afford it, or what we do is we believe it's part of the costs of the actual eventual claim in certain circumstances, not always, but yes. So that's how we deal with it. And it's, as I said, it's an efficient way of gathering evidence that might take us a long time and very difficult another way. The discovery process can be very difficult. We're not always given everything. It's nice to have that coronial just to see what's actually out there, so you get more of a clear picture about what may or may not be your case.
We'll get a clearer picture when all 3 of these scheduled inquests are held before the end of the year, and we'll bring you updates on Court in the Act about them when we can. Noor Blumer, thanks so much for sparing some of your valuable and precious time today. It's been an absolute pleasure.
Great to chat.
And thanks for all of you for joining us again. Please don't hesitate to get in touch with us by writing to courtintheact@wanews.com.au. Bring us some cases, if you like, that you'd like us to cover. Don't forget to like and subscribe to the cases that we've already covered. Tell your friends, your family, your colleagues, your co-accused, all about us. And did you know that if you subscribe with Google, then that allows you to subscribe to the West Australian using your Google account, or link to your current subscription of your Google account. It's simple, it's seamless, a way of accessing premium news content across all devices, giving you full control and flexibility. Subscribe with Google to the West Australian and you will never miss a headline. It's simple and secure, 2 taps and you're all set. Explore a world of quality news and journalism from the West. Seamless access, full control, easy to manage. Subscribe with Google. Go to thewest.com.au/Google and subscribe today. And remember, if you want to know what's going on in court, don't get caught short. Get caught in the act instead. See you next time.